Our first person who is scheduled to interview today is Ms. Molly Weber, and I welcome you before the commission today, and would invite you to make a short opening statement if you so choose to.
Yes, thank you. Good afternoon, Chairperson Justice Wiggins and members of the commission. Thank you for your service and dedication to this very important responsibility of selecting Iowa's next Supreme Court Justice. My goal is to serve the people of Iowa as an Iowa Supreme Court Justice. My experience for this position is diverse. In my 18 years as an attorney, I have been a judicial law clerk, a senior counsel for the United States Secret Service, and a trial attorney for the Iowa Department of Justice. I have had numerous recent civil jury trials during the past few years with our state's law firm, the Iowa Attorney General's Office. And I served as a lead or co-lead counsel in most of those trials, including a trial that was featured at Drake Law School and several complex multi-week trials. Now, in addition to my law degree, I have a master's degree in public policy from Georgetown University. And I did legislative and policy work during my time with the Secret Service. I believe that my public policy background would assist me in the administrative duties of the Iowa Supreme Court and in interacting with the legislative and the and the executive branches to advance the needs of our judiciary. Now, throughout my career, I have chosen to do public service. I turned down a much higher paying job in a Washington, D.C. Large law firm to serve in the government. I want this job because I want to do interesting and challenging work in a way that contributes to the well-being of society. And I want to do that for the people of Iowa. Now, if selected for this position, I would show 1, strong analytical, legal research and writing skills, 2, thoroughness and dedication, 3, integrity and impartiality, 4, collegiality, and 5, respect. Now, let me talk about those. First, I have strong analytical, legal research and writing skills. Now, judges are called upon to apply the law to the facts of a case, and that takes analytical and research skills to reach a well-reasoned decision. But that's not all. The decision then has to be written in such a way that it clearly conveys the reasoning and the result. My writing does that. It's easy to understand and reflects attention to detail. I served as a project editor while I was on the American Criminal Law Review at Georgetown Law Center, and I've had several articles published. But I believe that the best way to become good at drafting opinions is by drafting opinions. And I have drafted numerous opinions during my time as a law clerk. I've worked on complex cases, cases that involve both civil issues, criminal issues. I worked on an appellate decision. And I know that there will always be new and evolving areas of the law. And the Supreme Court is often faced with issues of first impression, and the court also answers certified questions of law that come from the federal courts. So I believe it's important to have the skills to be able to get up to speed quickly. And working on areas that are new to me would not be a problem. The work of an appellate judge is different than the work of a trial judge. And I believe that over my career, I have demonstrated the characteristics that are needed to succeed as an appellate judge. Now, second, I am thorough and have the dedication and work ethic to excel in this position. Every dispute is important to the parties, and I would give each case the attention that the litigants and the attorneys deserve. To the litigant, it is everything. It could be his or her freedom at stake. It could be the person's livelihood. It could be the relationship with a family member. The arguments must be given thorough consideration. The details matter. It is important to be accurate from the facts all the way through to the final proofreading and the citations in the opinion. Now, third, I would act with integrity and impartiality. Judges must be fair and decide cases without bias, fair and impartial, without regard to race, gender, economic circumstances, or other characteristics. Access to justice is what makes our system work. And that's why I believe it is so important to look for solutions to remove barriers and increase legal services for those who need it. My understanding of that began in law school when my third year at Georgetown, I was a member of the Criminal Justice Clinic. And in that clinic, I represented indigent criminal defendants who were in the Washington, D.C. court system. I want to do what is right according to the law, and I'm comfortable with asserting my views and articulating my decision, even if it is not popular. I am honest, and I will tell you what I think. I believe in the rule of law and the Constitution. I am not here to advance any personal agenda. I only seek to do justice. Now, fourth, I would show collegiality. I grew up in Centerville in rural southern Iowa, and then I went to law school and worked for several years in Washington, D.C. I have the ability to relate to people from all different types of backgrounds and to find common ground. I can get along well with others and work together to get the job done. Teamwork was often important in the cases that I have handled, and there is a real camaraderie that develops when you work on cases together. I enjoy that, but not only that, I think that being able to exchange your views with others who are working on a case opens your eyes to new insights that you had not thought about before, and it improves the outcome. I would show collegiality in my ability to listen to my fellow justices, to actively discuss cases, and to ultimately reach a decision. Fifth, I would show respect. Now, judges should make the right decision based on the law, but it's also important to treat attorneys and litigants with respect and dignity, to show them that their case matters. Now, one side will always be disappointed in the outcome, but people will remember how they were treated. You want people to know that they have been heard, that they've had their day in court, their voices have been heard, their arguments have been given full and fair consideration. That way, they will come away from the process with a feeling that it has been a fair and a just one. Now, in the United States Secret Service, we had a motto, and the motto was emblazoned on the wall of our main headquarters building in the lobby: worthy of trust and confidence. The courts should be that too. It is important that the litigants and the public respect and have confidence in the judiciary and in the process of how cases are handled in the Iowa courts. And I would do my best to promote that from within. Now, on the topic of respect, I would respect not just the power, but also the limits of the judiciary. I believe in the separation of powers and the three branches of government. The role of the judicial branch is to interpret the law, the role of the executive branch is to execute the law, and the role of the legislature is to make law. As judges, we may think we know best what to do in any given situation, but we have to be careful to restrain our actions so as not to intrude on the other branches of government. Now, another limit of the judiciary is that aside from rare exceptions, such as subject matter jurisdiction, judges should not raise issues or arguments for the parties. It confuses the separate roles of the system when judges become advocates for one side or the other. And another type of judicial restraint I learned from my first judge that I clerked for, the Honorable Harold Viator, and that is not to decide issues unnecessarily, but only to decide what needs to be decided for that case and to save the rest for another day. I want to address the topic of gender. I am proud that Iowa was the first state to admit a woman to the Bar of Attorneys in 1869, Arabella Mansfield. And I believe that gender can affect a judge's perspective when viewing the facts and in deciding cases, just as other aspects of a judge's personal background and circumstances can. But there is no separate category of female justice. I am an attorney. I'm not a female attorney. And if I or another woman is chosen, she will be a justice, not a female justice. The justices of the Iowa Supreme Court are equals, and I expect all to be treated as equal colleagues. Now, in conclusion, I made the choice to come back to Iowa. In a way, I have come back to my roots. I grew up in the small county seat town of Centerville, and I now live in the small county seat town of Adel. I understand how the local courthouse can be a source of pride for the community, the lifeblood of a community, and also provides essential services. And as for my personal life, I am a wife and a mother. My husband also grew up in Centerville, and we are the parents of 4 boys. There is a saying that the best predictor of future behavior is past behavior. The best predictor of how I would do on the Iowa Supreme Court is the quality of my past work and my commitment to public service. If given the opportunity, I would uphold and enhance the integrity and reputation of the Iowa Supreme Court. Thank you, and I'd be happy to answer any questions you may have.
Thank you, Ms. Weber. Well, I'm going to start on this side of the table. John?
Ms. Weber, thank you for coming. So we talked about this a little bit in the private interview, but I'm concerned about the criminal justice system in Iowa and the racial disparities. There was one study that showed that African American men tend to be arrested at 8.7 times the rate as white men, and that the incarceration rate of African Americans is, the representation of African Americans in prison and jail is 25% compared to being only less than 4% of the population. Given those numbers, do you have any suggestions or thoughts about what role the Supreme Court might take in addressing those disparities?
Mm-hmm. Thank you, Commissioner O'Brien. That's an important question. That is a serious issue, that statistical disparity. And I think it's a problem that would require some complex solutions, probably beyond what I've thought about, frankly, as far as what to do. But I think we have to start with the situation with the arrests and look at the rate of arrests that are happening and how that is impacting African Americans statistically on a greater number than it does other minorities or other genders and other races. And I think it's something where the courts can bring that awareness through their outreach, through their public speaking, through kind of the way that courts are responsible for educating different groups around the state, and the responsibility of the Supreme Court as the head of the judicial branch to make sure that others understand that that is a problem and work on solutions together to try to address that problem. And whether that's speaking to law enforcement groups, trial court judges, certainly different levels of the system, to try to find solutions to that problem. I think that would be important.
Mrs. Roberts, do you have any questions? Ms. Conover?
Ms. Weber, when you were working in the Criminal Justice Institute, I'm just curious how many semesters or months you were in there, and were you actually representing individuals? Did you ever go all the way through a trial with them? Were they misdemeanors? Were they felonies? Can you just give us some sense of that?
Sure. It was basically an academic year that I was involved in that, my 3rd year in law school, and I represented defendants that were in the first level of the DC court system. I believe it was misdemeanors, and the cases that I recall were drug possession, that type of thing. And as long as we as students were under the supervision of our clinic director, we could appear in court and do everything, act as their attorney. So I felt proud from the first time that I was given a case to handle that I had that responsibility even as a 3rd year law student, and a sense of, bearing that responsibility for my client to try to help him through the system. And the first one that comes to mind, I think we were able to, as I recall, get the case dismissed. It was on a motion to dismiss, may have been a motion to suppress due to the way that the evidence was found in that case. I didn't have a chance, I did not go through all the way to a trial or anything like that, but it was kind of the hearing, the initial process of receiving a case, and then some written work was involved with researching and writing briefs, and it was a great experience. I was happy to get that direct experience.
Thank you.
Thank you.
Mr. Bloom, do you have any questions?
No.
Mr. Goodman?
Thank you, Chairman.
Pull the microphone so the outside world can hear us.
Okay, Ms. Weber, can you hear me? Thank
Yes.
you. Thank you for your application.
Thank you.
You have a very impressive resume, work experience, and your work is very impressive as well. As an English major, I'm very impressed by your writing skills, which I think are very important. Later today and tomorrow, we're going to see 8 district court judges that are going to try to impress us that having district court experience is important and may be a prerequisite to this job, the Supreme Court. There are others who think that certain judges are cut out to be district court trial judges and other judges that are made of a different kind of fiber that are uniquely qualified to be appellate judge or justices. What I'd like to know from you is, what is your view on that? And have you ever applied to a district court for a district court position? And what information would you like us to consider on those 2 issues, trial court versus appellate court? Thank you.
Thank you, Commissioner Goodman, for that question. No, I have not applied to be a trial judge. I see that there are some differences, and as I touched on in my statement, between being a trial judge and being an appellate judge. And one is not necessarily a prerequisite for the other. There are certainly wonderful trial judges who do go on to become great appellate judges, and obviously we have a few on our Iowa Supreme Court, but it's not the only path. And I believe that simply being a trial judge doesn't necessarily mean that you're ready or equipped to have the skills to become an appellate judge. Some of the differences would be in kind of the in-depth analysis of the legal research and writing that is more of the work done at the appellate level than it is at the trial court level, where more of the work involves being in the courtroom and handling cases day to day, having that direct contact with the litigants in the courtroom, hearings, that kind of thing. And I think being a trial judge, I mean, it does call upon some different skills that are great skills. Trial judges have to be able to think on their feet and make quick, decisive decisions, that the parties can rely on and move forward and just keep going through the trial. But as appellate judges, there's a little more time for kind of looking at the record and to see if there was error that was done. And frankly, I feel I'm more suited in both my interests and the type of work that I feel that I'm better at would be the right research and writing and the time for reflection that are done as an appellate judge. I think thinking on my feet is probably not one of my strongest skills. I've gotten better at it. I've had to do it obviously with trial work, that you have to object on a moment's notice and make an argument, but it's not as much in my comfort zone as the time for research and writing in depth. So I think that there are differences that I hope that the commissioners do recognize, and that certainly we have some wonderful applicants, that are qualified as far as their skills, but there are differences. And being a trial judge does not mean you should automatically be prepared to be an appellate judge.
Thank you very much.
Mr. Sukup, do you have any questions?
Thank you, Mr. Chairman. In the past 10 years, you listed out trials that you'd gone to conclusion. They were all before juries and none before the bench. Was that your preference or the opposing?
Well, that's a good question. I liked having the jury trials. I did. They were all, I believe they were all employment discrimination trials. So there was the right to a jury in those situations, and the plaintiffs, wanted a jury trial, and that's fine. I kind of enjoyed that ability to be able to have a jury there and to be able to, direct arguments, closing argument or opening statement to the jury and talk to them directly. So I think it was a great experience to be able to do jury trials.
Thank you.
Ms. Diekman, do you have a question?
Thank you. Ms. Weber, I appreciate you coming in today. You touched a little bit on the issue of the Supreme Court obviously is faced with a broad range of issues. And one of the things you said, and I wrote it down, was that working on different areas of the law shouldn't be a problem. I'd like you to expand on that, given the fact that you primarily have worked in more of a single area. Could you do that for us, please?
Sure. And what I mean by that is that, in the Supreme Court, it's going to generally be issues of first impression, and there will be areas that, any justice on the court is not going to have a background in every single area of the law, equally, civil, criminal, family law. But I believe that that's not something that can hinder you, that would necessarily hinder you in the job. It's not going to be a problem if you have the skills to research and direct your efforts to that area of the law. Even if you don't have a substantive background in that area, you can do the work that's required to reach the right result. And frankly, you can talk about, issues with your other fellow justices who may have more experience in, for example, family law. And so I bring it up because obviously I've done mostly civil work, family law, areas like that. I don't have the background in that some of the other applicants do, but I believe the skills are there that I would be able to do the job. Thank you.
No questions.
Thanks for being here today. A further question or two on first impressions, and certainly, as you state, the Supreme Court is going to do a lot of Supreme Court type decisions, but, the human condition with technology, we seem to be, increasing our abilities and just new things coming out faster than anyone could have predicted. The rate of information, the speed of information is drastically increasing. Further and faster than the legislators can make laws around the new technology. So there are going to be things, in my opinion, that come to the Supreme Court, 5-10 years from now that we can't even think of because they haven't been invented yet. So what is your approach to, how should the Supreme Court approach something that there is no applicable law at all?
Mm-hmm. That's a good question. There will be areas that there are no laws that are applicable, but maybe, even if they're not areas that have been decided in Iowa, in the Iowa courts, perhaps other states have dealt with issues, and you can look to the example of how other courts in other states are addressing issues. And sometimes you have to do that to look to other sources of information, but I think it depends on the kind of case you're looking at, and if it's a statute, you want to look at the meaning behind the statute, the original intent of it, the text of the statute, and if there are different situations with technology that have come up, sometimes you have to make that adjustment between what the words of the statute say and then to account for differences in technology. But I believe that through, looking at other examples, perhaps in other states, that you can find a way to reach the right result, even in a case that might involve areas that have not been decided before. But as I said in my statement, as much as possible, you want to have the legislature make changes to the law, amend the law or through regulations, and so courts need to be able to do that to allow them to do their job.
Ms. Weber, I'm a city boy, but I have a real affinity for rural Iowa. I'm real concerned about the effect on rural Iowa of an evolving technology and the limitations that the budget brings. Can you help define for me what you see as the potential problems for rural Iowa and how you propose to be involved in it if you are a Supreme Court Justice?
Thank you. I do believe, as I said in my statement, it's very important to have essential services provided in rural Iowa throughout the state, at the county courthouses, at that level. There may be ways with technology that there could be cost savings. I know that the big concern is really the cost, obviously, of operating in all different, counties around the state, that sometimes with the budget needs of the court, that's a real consideration. And so maybe with kind of looking at different efficient ways to utilize technology, I think EDMS, the electronic system, has been a great development for the courts because people can access it from anywhere in rural Iowa and don't have to, be there in person to make your filing and to read on what's going on in a case. So I think the courts should continue to monitor new technologies and look for ways to utilize them around the state.
I think we have time for one question, so the last three decide who wants to do it. No question? Well, I guess I can ask a question. Okay. When you do this job, you end up with the administration of the courts, and you really haven't worked in private law, basically the government entity. Have you ever worked with budgets and making decisions like that in your jobs?
No, I really haven't done that, Justice Wiggins, but I have done work as far as, especially with my time in the Secret Service, that wasn't just, litigation type of work. It was legislative, it was policy, it was, working with other agencies, other officials, the director, the assistant directors. And I think that's something that I could that I would be able to handle. I think it's good to have the skills to be able to adapt and do other types of things, and I've shown that I've been able to do that in the past, and I would certainly do my best to do that on the court.
Okay, I think we're out of time, so I thank you.
Oh, it was off.
Okay.
I just got a text message. Why can't we hear you? So
Oh, okay.
it was off, but I really appreciate you coming in, and we'll give you due consideration. And thank you very much.